talk about the prevention of performance doctrine, you know, I think that there is an equitable component that just is fused into this legal concept. And one of the cases that was especially interesting that we cited too was this M3 producing versus Tuggle case. And it's interesting because like this case, it involves parents who passed and relationships among siblings. And in that case, the trial court applied what it thought was a plain reading of the contractual obligations, and it reached a result that was rather harsh. One sibling gets everything, the other sibling gets nothing. And up on appeal, the appellate court said, no, this isn't how the law works. You can't just sit by and wait for the other side to not perform and then yell, gotcha, yank the rug out from under your sibling, and take both your share and the other side's share. The court found that that was inequitable, that it resulted in a windfall, that it resulted in a forfeiture, and that that's not what the law is intended. And we think the same analysis applies here in this case. Another concern that we had with the trial court's decision was the way that the magistrate's decision was reviewed. So in this case, the trial court did not appear really to conduct an independent review, and we've cited to a couple of examples of why we believe that's the case, but I think the most telling is the trial court's words itself, which was, there's no error of law or defect on the face of the magistrate's decision. But that's not the standard to be applied in a case like this, where there were timely objections that were asserted. So we think that, you know, the magistrate kind of took, and I can understand the appeal of taking a position that, oh, she didn't exercise it on time, case closed, we're done. But the trial court really had the obligation to independently dig into that evidence and review it, and that didn't occur, and we know it didn't occur because the trial court wasn't even citing the correct standard when it was considering that issue. All three of these lead to a decision that results in Dawn not being entitled to any piece of her family farm, and Brian being entitled to both his share and Dawn's share. We had some other issues that we mentioned in our brief. There's an evidentiary proffer that we believe we should have been entitled to present. The trial court kind of glossed over that issue. It was one of the reasons that we think we didn't entirely get an independent review in this case. There was a $60,000 Cognovit note, which I agree was not, we did not plead a breach of that note. We wanted specific performance, but there's some language in the trial court's opinion that the other side is possibly interpreting as saying that note might not be enforceable, which of course is not the case. Everybody admitted that this note was enforceable. We even had an exhibit from a lawyer opining that the note was enforceable. So to the extent that the trial court seemed to suggest that that might not be the case, we definitely feel that we need some clarity on that $60,000 note. And then the case kind of all wrapped up in the final conclusion as it related to this summary judgment decision on fraud. And the trial court didn't engage with any of the summary judgment evidence at all, but curiously just kind of resorted to the pleadings and said, well, the complaint said X, Y, and Z, and that's not sufficient. Well, by that point, we had had a trial. We extensively cited to the record. Dawn had submitted an affidavit, and the trial court didn't engage in any of that record evidence. And finally, the trial court did bifurcate the issue. We agree normally that's discretionary with the trial court, but the way that you have to do it so you preserve the right to a jury. And by allowing the magistrate to try these very fact-intensive issues that deal with intent first, Dawn never got to the jury on her fraud claim, and the jury never got to decide those issues of intent.
You're getting into your rebuttal time now, so.
Very good. Then if the court has no further questions, I will reserve the remainder of my time for rebuttal. Thank you, Your Honor.
May it please the court. My name is TJ Evans, and I represent the defendant, App.No, Brian Simecek. We ask that this court affirm the trial court's judgment entry for judgment in my client's favor on the breach of contract claim and on the fraud claim. The trial court also granted my client's counterclaim for declaratory judgment. And in that declaratory judgment, the court determined, based on the four corners of the document, that Dawn Simecek failed to exercise her option within the vacant lot option period, that that the option agreement is null and void as a matter of law, that there's no language in the contract that requires Brian to split the lot before Dawn exercises, and there's nothing in the contract that requires Dawn.
But what do you say to the argument that in order to exercise an option for a vacant lot, there has to be a vacant lot?
The vacant lot absolutely exists, Your Honor, and it's in, that property is within the possession of.
But as a part of another property, it hasn't become its own land.
But what the case law says is the property can be conveyed if it doesn't exist, if it's capable of being performed. And here it is.
Capable of being divided? Or,
Absolutely.
but if they're, so capable of being divided is enough to just say that this vacant property already exists?
Absolutely, Your Honor, because here the vacant lot itself was identified. The parties had discussions before the option agreement occurred, and that's in paragraph 17 of the complaint itself, that the properties had a boundary of the property. They knew where the boundary of the vacant lot was. There was a mechanism in the contract itself that gave.
But the words vacant lot imply that the whole thing is vacant. If it's all on one property and there's a house on it, it's not a vacant lot.
The vacant lot is specifically defined in the contract, Your Honor. It's defined as the 1 1/4 acres. The home lot is the one with the house located on it, the other having at least 1 1/4 with the vacant lot, which everybody knew at the time also consisted of the ancillary building, the barn. At that time, everybody knew what the vacant lot was, and in fact, the property split. And there's no dispute right now that the vacant lot is exactly what the parties identified before the contract and during that contract. So that vacant lot was specifically identified before the contract.
Is she even capable of buying the lot if it's not divided?
Absolutely, Your Honor.
So she could exercise an option and then she could automatically have the vacant lot?
Right, because what's lost here, Your Honor, is that we have an option contract. A contract that does not become an effective bilateral contract until there's an exercise of an option. The option must come first. And we're talking about the timing. We're talking about the recital provision in the contract, that Brian Simecek will be attempting to split the lot. When? The recital provision itself is not an enforceable contract obligation. Is it pointless? Is it meaningless? Absolutely not. It will show, it will elucidate the party's intent. So when is he required to split the lot? The closing provision covers that. Within 30 days after Dawn exercises her option to split the lot, or exercises her option to purchase, he's required to split the lot and close on the property. Now, if we look at this,
Where is that in the contract?
paragraph 6 of the option contract, Exhibit B, Defendant Trial Exhibit B, that if the vacant lot option is timely exercised, the vacant lot closing of the sale and purchase of the vacant lot shall occur in no event later than 30 days after the date of exercise.
So that sounds like closing, not dividing.
He has to close and provide a warranty deed to that property within 30 days, absolutely. And if he does not, if as opposing counsel attempts to point out that if it is impossible to do that, he's in breach, and that's his problem. He has to perform within that time period. But the one undisputed and inescapable fact here, that Dawn never exercised her option to purchase. We would not be here today if Dawn exercised her option to purchase. There would be no breach claim, there would be no fraud claim. The property
This
would
is a very poorly drafted contract as far as what each of these people are supposed to do. Obviously, her perspective is, I couldn't purchase anything because there was no properly drawn up lot. His position, I take to be to some extent, why should I split until I know what she's doing? I'm gonna run a bunch of money up. If she doesn't want it, why should I spend that money? So we have a poorly drafted contract that didn't lay out their rights well under this agreement, what they're supposed to do.
Well, the parties agreed that this contract is clear and unambiguous. And in fact, that's what plaintiff has to prove here. She has to prove that this contract is certain, that it is definitive, that it is unambiguous, and that it is capable of a specific decree of the court. That is what is required by specific performance. She has to prove that it's unambiguous, otherwise she's not entitled to specific performance. And here, we think the contract language is clear, and I think that the practicalities, Judge, that you just mentioned, that why would he be required to split this lot, to spend the money, spend the time, if she ultimately doesn't exercise? And that's truly Dawn's position throughout this whole case, is she has to do nothing. She did nothing. Meanwhile, Brian, on the other hand, he has all the risk. He extends an olive branch to his sister here and says, you want a part of this property? You're my sister. I want you to have it. I will give you an option to purchase this property. He doesn't want to spend more money than he has to. His goal this entire time was to purchase a house, spend the property. Otherwise, if his brother wanted more money for it, that they were just going to put it through the probate. But meanwhile, throughout this entire contract, Brian has all the risk. Brian has to pay insurance. He has to pay taxes. He has to maintain the property. If the property value...
Going back to being a polygraphed contract, should that have been included in the contract in the first place to say who's going to pay this, who's going to have to pay the cost of the lot split?
I think you're right, Your Honor. It is silent as to who is required to pay for it, but ultimately, the record shows that Brian was paying for it. He did ask his sister for help, and she said, no, I'm not going to financially help you split the lot. And he said, okay. He still took effort. The trial court found that he still tried to split the lot within the vacant lot option period. He wasn't required to. He was only required to after she exercised her option.
And that was the effort you're referring to, or the same ones that council talked about back in October of 2020. There's nothing part of that.
Yes, Your Honor. The record evidence shows that in the beginning of 2020, he was reaching out to contractors. Initially, he didn't realize that he was going to have to split off and abandon the septic, run a sewer line to the house, go through his foundation of his house, spend $30,000 to $40,000 of his own money to help his sister, acquire this lot.
So he was making, the record will show that he was making those efforts sometime at the start of 2020. So that was the second year of the contract. He was making some efforts.
Absolutely, and I think we'll all recall back in this time period, we were going through a pandemic, and contractors were very difficult to obtain, whether they were going to be able to perform timely. That was certainly an issue that he ran into, and I think both Don and Brian were well aware of those issues that contractors were difficult to come by at that time period.
So your position is the right result is that Brian gets the whole property and she gets nothing?
She didn't get nothing. She got a $60,000 check, which was required by the time limit.
So
He delivered it.
You're saying because she rejected that check, then she's left with nothing?
Based on her decision to refuse the check and file the claim, well, I can't say that she's left with nothing, Your Honor. At all times throughout this case, my client was willing and able to pay the $60,000 to his sister. So I can't say for certain that he's withholding it. I don't see that the trial court judgment says that she's not entitled to it. What it did say, but she didn't ask for it. I think that's undisputed. The cognovant note is not attached to the complaint. It is not referenced in the complaint. It is not asked for in the prayer for relief. We didn't try a claim for breach of the cognovant note. In fact, how could you really? My client tendered performance and the check was rejected. So there is no real breach of contract claim as it relates to the cognovant. But what the record does show is that my client, upon the expiration of the vacant lot option period, sought out an opinion from a lawyer to say, what do I do here? What's my obligations? And as a result of that, he submitted the $60,000 to his sister. He at all time has acted with good faith in this case. Meanwhile, on the other hand, his sister's done nothing and expected everything from her brother.
Is the doctrine of good faith consistent with specific performance requests?
The doctrine of good faith and fair dealing applies when there is an actual breach of a contract provision. So without an actual specific breach of a contract provision, to point to a provision and say, he breached this provision and he failed to perform with good faith and fair dealing. So it can, in theory, apply to a specific performance claim, but doesn't apply at all here, because there is no specific breach of a provision in the contract. There's nothing that can be pointed to other than a recital, and that recital can be read in conjunction with the closing provision. He's required to split that lot as soon as she exercises, because the practicality of it is, why would he be required to spend that money, spend the time, the effort, split the lot, and then have it not purchase the property? That may have been more valuable as part of the larger property. It may have been more valuable to be split off ultimately. And beyond that, to split the lot, he would need to get a survey, and then to actually convey the warranty, he has to get another survey that complies with an owner's policy. So now you're requiring them to get two separate surveys that in practicality doesn't make sense when it can be done at the same time in conjunction with the closing provision. We heard a few other arguments by counsel about whether there was an independent review, what's required from the trial court to do an independent review. It's whether the magistrate properly determined factual issues and whether the magistrate appropriately applied the law. That's precisely what Judge McLaughlin did. And the way that the actual specific objections were worded were the magistrate failed to do X, the magistrate failed to do Y. So the trial court appropriately viewed what the magistrate did and said that what he did was right. There's no indication that she didn't independently review the record. There's no indication that she didn't independently review the evidence. But she absolutely independently reviewed the magistrate's decision in this case. We talked briefly about the $60,000, the fraud claim. Opposing counsels conceded in her brief that the contract claim and that the fraud claim are factually intertwined. That in and of itself precludes a fraud claim. There's no separate independent duty, there's no separate independent duty alleged, there's no separate independent money damages that were alleged or shown. The trial court also found that she failed to plead with specificity, and opposing counsel relies on her competent summary judgment evidence, which consisted of an affidavit by Dawn that was solely upon information and belief. In the complaint, they referenced numerous emails, numerous text messages that conveyed fraud. Not a single text message was offered in the affidavit. Not a single email was offered in the affidavit. And in fact, what Judge McLaughlin found was perhaps the alleged fraud doesn't exist at all because it was undercut by the breach trial. The fact that Dawn claimed, oh, Brian, you told me that you were going to draft these contracts based on forms you found on the internet when you really had a lawyer. Well, she flat out knew in the text messages that were brought out during the trial court for the bench trial that he had a lawyer. And the other allegations of fraud simply don't meet the requirements of fraud, and Dawn made no effort in her summary judgment to prove that she met each element of fraud. And then there's Dawn taking issue with the bifurcation. I filed a written motion for bifurcation, and I understand that there's a different attorney that represented Dawn at the trial court. She wasn't aware of what happened at the pre-trial. She wasn't aware of what was happening at that time. But we filed a written motion for bifurcation, and that was not opposed. There was some opposition at the actual pre-trial conference that the case should not be bifurcated, but there was nothing more than that. There was no case law cited. There was no actual written decision cited why bifurcation was inappropriate.
So would it be fair to categorize that as an oral objection?
Absolutely, Your Honor, but it wasn't an objection as to, hey, you have to do these trials together and then the specific performance is done by the judge. It was just a basic objection, Your Honor. So it wasn't, hey, you can't have a bench trial first and then do a jury trial later.
The discussion at the pre-trial part of the record before us at this point in time?
The discussions at the pre-trial were not before the court, other than what Judge Lanziger pointed out, that the trial court itself noted that there was an opposition at the pre-trial in one of her written orders. But at no point was there a written objection specifying how the process should happen. At no point did opposing counsel object before the bench trial actually occurred, and at no point did he object during the actual bench trial itself. So really what this case boils down to is the fact that Dawn never exercised her option to purchase this property. And the first question I believe, Judge Stevenson, that you asked was, that opposing counsel mentioned, was that she was denied her opportunity based on Brian's actions. The only thing that denied Dawn of her opportunity to purchase the vacant lot was her failure to send a written notice saying, I am exercising my option to purchase this property. So we ask that this court affirm the trial court's decision, awarding judgment in my client's favor on the breach of contract claim and the fraud claim. And I would also posit that the counterclaim for declaratory judgment, that still stands. There's no assignment of error associated with that. We pointed that out in our response brief, and that was not replied to in the reply brief. Thank you for your time. If there's no further questions, appreciate it.
See none, thank you.
When opposing counsel read the definition of the vacant lot, he indicated the portion of the definition that related to the acreage, but failed to mention the part of the definition that said Brian Simecek will be attempting to split the current lot into two separate lots. One is this, the other is this. The vacant lot is what results when he attempts to split it. He didn't do that, it didn't exist, and Dawn could not exercise her option over it. She was waiting and waiting and waiting for that to be done, and it wasn't. There was some suggestion that why would he have to incur the expense to do that, or maybe some sympathy for the carrying costs. But the contract anticipated all that. The testimony said that the parties anticipated the lot split, and just look at what she's paying. You know, the parties said the entire lot, including a house, an improvement, is worth $180,000. She's gotta buy the vacant lot for $130,000. So the deal absolutely anticipated that there would be costs to split this lot, and she's gotta bring $70,000 new money to the table in order to acquire the vacant portion. So the parties did anticipate Brian would be making those expenditures. The contract required him to do this lot split within a reasonable time. I disagree with the assertion that there was any effort at the start of 2020. The record does not show that. The first thing that we have actual evidence of is the email on October 8th of 2020, and the appraisal on October 9th of 2020.
Did Brian testify he was making some efforts?
He testified that he made efforts. He did not testify as to a timeline. The magistrate's decision said sometime in 2020. So there certainly wasn't either a finding or testimony that it was early 2020 that any of this was occurring. In any attempt, what he was supposed to be doing was attempting to split the lot within a reasonable time, and we don't even have an application. How can you be in good faith attempting to split a lot when for 2 years you do not even apply to split the lot? If it was true that this lot could be split just as a matter of course, as he was suggesting in response to Judge Lanzinger's question, there would have been nothing to preclude him from applying for that lot split early on. But that's not the case. There were several things that had to be done before the lot could be split, and he didn't take the effort to do that and didn't comply with his obligation to, in good faith, attempt to split the lot within this
Council,
period
I
of
know
time.
your time is up if you briefly conclude.
If Dawn and Brian's parents could see the result that happened today, I think we all know this is not what they want. Fortunately, equity allows us to right this wrong, and we'd ask that the trial court be reversed.
And thank you to both councils for your presentation today. The court will take the matter under advisement and issue our decision in due course. When that decision is reached, we mail to you by the clerk of court, and also be involved